Hello everyone, I am Swati Singh Parmar, Assistant Professor, Dharmashastra National Law University, Jabalpur. Today we will talk on refugee laws. And in our today's discussion, we will focus on refugee. So we'll look at the definition of refugee. Then we will see who is an internally displaced person or IDP. Then we will see who is a stateless person. Then who is an asylum seeker, and eventually we will discuss about Geneva Convention and we'll look at the widely known principles of the Geneva Convention in detail. So let us begin with who is a refugee. So when we use the term refugee, what is that we mean? Refugee is a legally defined term. It is a legal term and it should not be used loosely or casually by anyone who does not understand the legal ramifications of the word. So, as per the Cambridge Dictionary, refugee is a person who has escaped from their own country for political, religious, or economic reasons or because of war. So Cambridge Dictionary defines a person to be refugee if a person has escaped from her or his country because of any of the following reasons. One may be political, religious, economic, or due to war. So these are the four broad reasonings. If due to any of these a person escapes their country, then that person qualifies to be called a refugee. But is that all? No, that's not all. So let's look at another definition of a refugee, which is given by United Nations High Commission on Refugee, or UNHCR in short. It defines a refugee to be a person forced to flee their country because of violence or persecution. So, if a person is forced, a person is fleeing from their country, but they're fleeing not because of their choice or their will, but they're forced to do so because of violence or persecution or threat of either of these, then the person is considered to be a refugee. Again, the UNHCR discusses the word refugee in detail and it notes that a refugee is someone who has been forced to flee his or her country because of persecution, war, or violence. A refugee has a well-founded fear of persecution for reasons of race, religion, nationality, political opinion, or membership in a particular social group. Most likely, they cannot return home and are afraid to do so. War and ethnic, tribal, and religious violence are leading causes of refugees fleeing their countries. So, it notes the few highlights of this paragraph. It notes that the people who are moving or fleeing out of their country due to some force are doing so because of the fears of war, violence, or persecution. The persecution, this word comes on and off when we talk about refugee. So, what is persecution? Persecution is threat or mistreatment which is done systematically against a person or a group of persons. So a person flees due to this persecution, due to systematic mistreatment of the person or a group or a community to which the person belongs to. And this fear that I will be persecuted or I'll face violence because of which I'm flying from this country to my country to another country. This fear has not to be a casual fear or a fear which is not well grounded, but this fear has to be a well founded fear. So it notes here that a well-founded fear, it notes that a refugee has a well-founded fear of persecution. And this well-founded fear of persecution can be due to various reasons like race, because one race is threatening another race, one religion may threaten another religion, one person who belongs to different nationality, he comes to another state and he faces persecution. Then, due to some political opinion that a person holds, he or she may face persecution or violence, or due to membership of a particular group or community, due to which he or she may face violence, war, or persecution. So, these are the reasons that function in background in creating a refugee. So, a person is created refugee because of these, a combination of these issues. And also, the person most likely has this fear because of which the person does not want to return to his home country, homeland, or is afraid to do so. Now, this is about a refugee. But then there is another term which is frequently used along with refugee, and that is internally displaced person, or IDP in short. So let us look at the definition of an IDP as provided by United Nations High Commission for Refugees. The UNHCR defines an internally displaced person, or IDP, is someone who has been forced to flee their home but never cross an international border. So, in case of refugee, we saw that definition highlighted that the person flees from their country. They flee from their home country and go to land in some other different country. In this case, a person flees from his home, maybe from his home city or his home district or his home state, but he does not cross his nation. He does not cross his national boundary. That means that a person has been displaced, but the person has been displaced internally within the state to which he belongs to, within the nation to which he belongs to. So, therefore, this person who's an IDP is a person who's displaced because of similar reasons, because of some violence or some internal disturbance. But then this person does not cross an international border to be called a refugee. So, there is a slight difference between refugee and IDP. The reasons in creating a refugee or creating a person to be internally displaced person, the reasons may be same, but the fact that a person does not cross an international border, that is the distinguishing feature between an internally displaced person and a refugee. Further, the definition says these individuals seek safety anywhere they can find it, in nearby towns, schools, settlements, internal camps, even forests and fields. IDPs, which include people displaced by internal strife. So, these are the people who are displaced due to some internal disturbance or internal strife or some insurgency within a state, and they may take refuge. They may go and hide, find a safe place inside a building, in an adjacent town, in a neighborhood city, in some settlement, in a camp, etc. But they do not cross international borders. Now, having understood a refugee and an internally displaced person, let us look at who a stateless person is. So, who is a stateless person? A stateless person, as the name suggests, is a person who does not belong to any state. That means a person who does not have citizenship of any state. Now, this citizenship, the loss of citizenship, may happen due to a lot of reasons. And what is basically a citizenship? Citizenship is a bond. It is a legal bond between the government of a state and the individuals of the state or the citizens of the state. And due to this legal bond between the government and the citizens, there are certain rights and responsibilities with the individual. So, because of citizenship, the individual who then qualifies to be a citizen has political, economic, social, financial, other rights. similarly, that individual now has responsibilities, and now that even the government has responsibilities to protect the citizen in the framework of a welfare state. So citizenship is a legal bond that creates rights and responsibilities of the government and the individual, and it ties government and individual together. And imagine if a person does not have citizenship of any of the country of the world, then how peculiar or complex that problem can be for international law for that person. Now, how does a person become stateless? A person can become stateless due to various reasons. These reasons may be some sovereign reasons. So, a state may declare a person X, as not our citizen. So, this is a person X who is citizen of state A, and due to some of his activity, state is now of the opinion that person X now no more enjoys the citizenship of our state, and he is not our citizen. In that situation, that person is not a citizen of state A and is neither a citizen of any other state. So that renders that person a stateless person. Again, there could be a legal issue. Due to a legal complication, the person may be rendered stateless. So a person who gives away his citizenship of a state, and because on because of the apprehension of getting a citizenship of some other country, and the person's citizenship for some other country, that application gets rejected, so that person in that time frame is in limbo, and that person is rendered stateless, maybe in such a situation. There can be technical reasons, and then there can be administrative decisions or other oversights in which a person may be rendered stateless. Now, a very important document on human rights, which we know as Universal Declaration on Human Rights, that was created in 1948. It is a document that enlists various broad human rights that each person on this earth is entitled to. Now, UDHR is a very primary and basic document on human rights. And UDHR, along with International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights. So these three documents collectively are known as the Universal Bill of Rights. So these three documents are the pillars of human rights law in international domain. So the UDHR, or the Universal Declaration of Human Rights, that was created in 1948, it mentions that everyone has a right to a nationality. So it gives you hint against statelessness of any person. Now, moving to another important term that revolves in our discussion on refugee-related issues, and that term is asylum seeker. So, who is an asylum seeker? A person is known to be an asylum seeker when the person flees from their state, his or her state, and then lands up in another state and seeks or requests for having asylum in that state. So a person has on some well-founded fear of persecution, violence, or war, flees from his or her state and goes to another state. Now, in this another state, when the person arrives, the person seeks an asylum. If the person is granted an asylum, the person qualifies to be a refugee. Till the time his or her asylum seeking application is in the process, he is called an asylum seeker. And when the process is complete and he is rightfully given asylum in that state, that gives him the legal status of a refugee in that state. So there is this distinction of seeking asylum and asylum being granted for calling a person to be asylum seeker or a refugee, right? Now, when a person who seeks an asylum, he or she applies for asylum, that is, they are requesting the government, the asylum giving government, or the refuge, the government in which, the state in which they're taking their refuge, they're requesting that government to give them the right to be recognized as a refugee. And once their application is approved, they become a refugee. And therefore, once they become a refugee, they are entitled to legal protection of a refugee and other assistance, that may be food, shelter, etc. That is for their basic amenities of the life. Now let us move to a document that deals with refugee law related issues. That is a primary document on refugee laws, and it is called as the Geneva Convention, that was created in 1951. Geneva Convention is the primary or the main document that talks about refugee law internationally. And it was entered into force on 22 April 1954. Geneva Convention has been amended once, and that was in 1967. It was amended in the form of a protocol. The protocol which amended it is known as the 1967 Protocol. Now, Geneva Convention, why was it amended? Geneva Convention was amended because the 1951 Geneva Convention was initially aimed at protecting the European refugees in the aftermath of the Second World War. And later, when it was felt that it is an important document for protection of refugees even outside Europe or even outside the domain of World War, then the 1967 protocol brought an amendment to widen the scope of Geneva Convention and expanded the Geneva Convention to be applicable universally to any refugee in the globe. Now, this Geneva Convention, it provides for the definition of refugee, and it talks about the different kinds of legal protection that a refugee has. It also talks about different assistance that the government of the state in which the refugee is taking refuge should give to the refugee, including certain social rights that the refugee can receive. It also defines certain obligations that the refugees will have towards their host government or the governments where they're taking refuge. Now, beyond doing this, it also talks about certain categories of people. One such category is war criminals who would not qualify to be refugee. So, if a person is there who is a war criminal, who is accused and proven to have uh, acted in a war crime, to have committed a war crime, and then due to the fear of being prosecuted in a home state or due to the fear of getting punished in the home state, politically or legally, that person flees from his home state and tries to take refuge in any other state. Such people, such category of people who are war criminals, they do not qualify to be given a refugee status. This also is explicitly mentioned in the 1951 Geneva Convention. Now, if we talk about the most significant principles of the Geneva Convention, then there would be these three. First, the principle of non-discrimination. The refugees should not be discriminated on the basis of religion, caste, race, sex, their region, their color, their political opinion, etc. Then non-penalization of refugees, and then the principle of non-refoulement. We'll discuss about non-refoulement in a little detail. Non-refoulement is a principle that binds the states for not sending the refugee back to their home country till the time the fear of persecution persists. So till the time there is well-founded fear that if they go back to their homeland, they will face some violence, systematic threatening, mistreatment, etc. Till that time, the host state cannot forcefully send back the refugees to their home state, because then if they go to their home state, they may face serious human rights violations. So this non-refoulement principle is a very significant principle of the Geneva Convention and broadly of refugee law that binds host state in a very different manner. Now, there are debates on non-refoulement, the principle of non-refoulement, and that the debates have established the principle of non-refoulement as a jus cogens norm. Jus cogens are certain preemptory or fundamental norms in international law which are to be followed by the states no matter what. This no matter what means that whether or not a state has signed or ratified a treaty, a state cannot say that we will not follow this principle because we have not signed or ratified this treaty. So whether or not a state has ratified or signed and ratified a treaty or not, a state is obliged to follow those norms. Those norms qualify to be called as jus cogens norms or most fundamental or preemptory norms. So non-refoulement has been established in the domain of international refugee laws to be the jus cogens. Now, the 1951 Geneva Convention also lays down certain basic standards, certain minimum standards uh, for treatment of refugees by the host government. And these standards are to be performed, to be followed without prejudice to states granting a favorable treatment to a category of refugees. So states cannot give favorable treatment to one category of refugees and give a not so favorable treatment on to the other categories. Now, this thing that I'm saying is a uh, is an example of non-discrimination norm, which is a very important principle of the Geneva Convention. And such rights that the state must give in a non-discriminatory manner to the refugees include the access to the courts. So, in case of human rights violations of the refugees during their stay in the host state, they should have access to courts in case of any of their human rights violations. They should have right to primary education. The host government should also ensure that they have right to work. If they wish to work, they can. Then the host state also has to ensure that there's a provision for documentation, including the refugee travel document in a passport form within and outside the country. So these are broad category of rights that the host state has to ensure for the refugees. And these are to be given to all refugees in a non-discriminatory manner, without favorable treatment of one category of refugee in comparison to the other one. Now, let us talk about certain underlying principles of the Geneva Convention 1951. One of the most fundamental principles is the right to seek asylum. Every individual who flees from his or her state on the fears that we discussed a while ago, all those have right to seek asylum. Also, the UDHR in its Article 14, the Universal Declaration of Human Rights in its Article 14, talks about this right to seek asylum is there to everyone in any other country. So it states that everyone has the right to seek asylum in other countries from persecution. So due to persecution, if a person has to seek asylum, he has a right or she has a right to seek asylum in any other country. Then another principle is the principle of non-refoulement, which I briefly mentioned. So principle of non-refoulement is not sending back the refugee to his or her home state till the time the fear of persecution persists. So it lays down a prohibition on the host state from returning the refugee back to his or her host country, where they continue to have a well-founded fear of violence, war, or persecution. Another significant uh, principle of the Geneva Convention is the principle of non-discrimination. And as we know that the principle of non-discrimination is a cross-cutting principle across various conventions on human rights, it has a similar high priority in case of the Geneva Convention. By saying high priority, I do not mean that there's a priority between the principles, but I say this in respect of the significance accorded to the principle of non-discrimination. So non-discrimination is a very fundamental principle of Geneva Convention, and the convention says that the provisions of this convention are to be applied without discrimination to the race, religion, or country of origin of the refugees or the asylum seekers. The principle of non-discrimination is embodied under Article 3 of the Geneva Convention. The various international human rights laws and the development in those laws, they have reinforced this principle of non-discrimination, and they have reiterated that this principle has to be seen when the provisions of the conventions are being applied. So, for example, if the rights to court, rights to access to court, or right to primary education, or right to food, water, shelter, or right to work is being given to refugees, it must be ensured that it is done in a non-discriminatory manner. So this non-discrimination to be followed when the convention's provisions are being applied. This is mentioned in several other international human rights documents. Now, another principle of Geneva Convention is non-penalization. So, Geneva Convention mentions that except for certain situations, the refugees should not be penalized for their illegal entry or stay. And this is reasoned in the fact that an asylum seeker or a refugee flees from their home state in a state of chaos, in a state of havoc, in a state where it may not be humanly possible to think about uh, the process of traveling, but to save life would be a primary consideration. So, a person who's fleeing from his or her country, leaving his or her home, all tangible and intangible goods beside, that person may not have a moment of deliberation, may not have time to think and reflect on whether to carry a passport, whether to book a flight, how to travel. So these considerations, that person may not be in a situation to think and reflect on this, and the person may not have such moment of deliberation, and the person may have um, uh, may have crossed international borders by some extra legal means, and that extra legal means should not be a hurdle in that person getting an entry, or that person should not be called an illegal person, or such an entry should not be considered an illegal entry or illegal stay. So the background factors in which the person flees and the compulsions in which the person could not have a passport, he or she did, maybe they did not have a passport, maybe they had a passport but they did not have time to collect the passport. Maybe they had the passport, but they did not have time to book the flight. Maybe they did not have any means to think about either of these. So these background factors are to be taken into consideration when deciding about penalizing a person for his or her illegal entry into a state or stay into a state. So these factors are to be considered, and this is underlined in the principle of non-penalization. With that, I will end today's discussion. In our today's discussion, we talked about the definition of a refugee. Then we moved to the definition of an internally displaced person. Then we talked about a stateless person. Eventually, we talked about an asylum seeker and the difference between an asylum seeker and a refugee. And then we discussed about the 1951 Geneva Convention, the 1967 protocol to it, which expanded its scope. And then we discussed about 4-5 important principles, including the principle of non-discrimination, non-penalization, non-refoulement, right to seek asylum, and others, which are embodied in the Geneva Convention. With that, I would end our today's discussion. Thank you.